I want you to think about a rule that looks small on paper but can change the entire outcome of a family. It is called the Medicaid 5-year look-back. That name sounds administrative. It sounds like something buried in a government manual. It sounds like a technical rule for lawyers, caseworkers, and nursing home billing departments. But in reality, it is a rule about your house. It is a rule about the money you gave your children because you loved them. It is a rule about the check you wrote to a grandchild at Christmas. It is a rule about the car you signed over because you thought you were helping someone get to work. And it is a rule that many seniors only discover after the options have already disappeared. If you are older, if you own a home, if you have savings, if you have children you hope to leave something to, you need to understand how this machine works before the machine is already moving. Because when long-term care enters the picture, the system does not behave the way most people think it behaves. Most people imagine a simple sequence. You get older. You need help. You use your savings. If the savings run out, Medicaid steps in. Then after you pass away, whatever is left, that is the picture many families carry in their heads. It is comforting. It seems logical. It seems fair. But the real system has a different sequence. You need long-term nursing home care. The cost is enormous. You apply for Medicaid because private savings cannot keep up. Before Medicaid pays, the state examines the last 60 months of your financial life. Not just the big transfers, not just suspicious transfers, every transfer, every gift, every check, every asset moved out of your name. And then the system asks one question. Did you give away money or property that could have been used to pay for your care? If the answer is yes, the penalty begins. This is why the 5-year rule is so dangerous. It does not punish fraud only. It punishes ordinary behavior that families have done for generations. You helped a granddaughter with tuition. You gave your son money when his car broke down. You wrote birthday checks. You helped pay for a wedding. You gave to a church. You sold an old car to a nephew for almost nothing because you wanted to be kind. These things may feel like family life. To Medicaid, they can look like asset transfers. And the system does not care whether your motive was love, generosity, habit, or ignorance. It only cares whether the asset left your control within the previous 60 months. That is the part most people do not understand until it is too late. They think the government is looking for people who intentionally hide money. But the rule is broader than that. It can catch people who never intended to hide anything. It can catch people who made gifts long before they ever imagined they would need a nursing home. It can catch people who followed the tax rules and still violated the Medicaid rules. That last distinction matters enormously. The IRS may allow a person to give a certain amount each year without creating a federal gift tax problem. But Medicaid is not the IRS. Medicaid is a different system with different incentives, different tests, and different consequences. A gift can be perfectly acceptable for federal tax purposes and still create a Medicaid penalty. Many seniors hear about the annual gift tax exclusion and think, if the IRS allows it, it must be safe. That is a very expensive misunderstanding. When you are dealing with long-term care, there are at least 2 rule books. One rulebook concerns taxes, the other concerns Medicaid eligibility. Confusing the two can put the house at risk. Let me explain the mechanics in plain language. Suppose a person needs nursing home care. The annual cost can be well over $100,000. In monthly terms, it can be more than $9,000. Most families cannot sustain that for long. So eventually the family applies for Medicaid. The state does not simply say yes because the applicant now has little money. The state asks what happened to the money during the previous 5 years. If there were transfers for less than fair market value, the state totals them. Then it divides that amount by a number called a penalty divisor. The exact divisor depends on the state. It is meant to approximate the monthly cost of care in that region. The result is a number of months. During those months, Medicaid will not pay. That penalty period can create one of the cruelest financial gaps in the entire elder care system. You no longer have the transferred money because you gave it away. But because you gave it away, Medicaid refuses to pay for a period of time. Meanwhile, the nursing home still wants payment. The bill keeps arriving, the family panics, and the assets that people thought were safe suddenly become targets. That is why I think about this not as a legal technicality but as a cause and effect chain. The transfer creates the penalty. The penalty creates the unpaid bill. The unpaid bill creates pressure from the facility. The pressure from the facility creates claims, liens, lawsuits, and forced decisions. By the time people see the chain, they are often standing near the end of it. At that point, the conversation changes from how do we protect the home to how much can we still save. Those are very different conversations. One is planning, the other is damage control. And the difference between them is usually time. Time is the hidden variable in this entire story. The 5-year clock does not start when you become worried. It does not start when you call an attorney. It does not start when your children begin talking about nursing homes. It starts when the assets actually move into the right structure. If the structure is not created and funded, no clock is running. That means many families who believe they are thinking about planning are not actually planning. They are only delaying. And every day of delay adds one more day to the back end of the risk period. This is why I say the most expensive day is often the day after you should have started. Now let me talk about the house, because the house is where most of the emotion sits. For many families, the home is not simply an asset. It is the place where the children grew up. It is the result of decades of work. It is the proof that a family built something. It is the one thing parents believe they can leave behind, and most seniors believe the house cannot be touched while they are alive. There is a narrow truth inside that belief. In many situations, the home is treated as exempt while the Medicaid recipient is alive, especially if a spouse is still living there or if certain intent to return rules apply. So people hear that and think the house is safe, but exempt while alive is not the same as protected forever. That is the trap. After the Medicaid recipient dies, another machine can turn on. It is called Medicaid estate recovery. Federal law requires states to seek recovery from the estates of certain Medicaid beneficiaries who received benefits after age 55. The main target is often the house. The state can file a claim against the estate. The heirs may be told they must pay the amount owed or sell the home. This is the part many families never see coming. They thought Medicaid paid because the parent had no money. Then after the funeral, a letter arrives. The letter is not emotional. It is not interested in memories. It is not interested in what the parent promised the children. It is a claim, and claims have consequences. The family suddenly learns that the home was not a gift already delivered to the next generation. It was an asset sitting inside a recovery system. The difference is enormous. I have seen people misunderstand this because they think in moral terms while the system thinks in statutory terms. The family says, "This was my mother's home." The system says, "This was an estate asset." The family says, "She wanted it to go to the grandchildren." The system says, "Medicaid paid for care and has recovery rights." The family says, "We did not know." The system says, "The rule still applies." You can dislike that reality. You can think it is unfair. But if you want to protect a family, you must understand the system as it is, not as you wish it were. That is one of the most important principles I learned in dealing with money, debt, policy, and human behavior. Do not confuse what should happen with what will happen. Good decisions come from looking directly at reality. The reality is that long-term care can consume savings at a speed most people cannot imagine. The reality is that Medicaid has eligibility rules. The reality is that the look-back period can punish transfers made years earlier. The reality is that estate recovery can reach the house after death. The reality is that adult children can also be exposed in certain states under old filial responsibility laws. That last point is especially uncomfortable. In many states, there are laws that say adult children can, under certain circumstances, be held responsible for unpaid care bills of parents. For years, many people assumed these laws were irrelevant because they were rarely used, but a law that sleeps is still a law. And when financial pressure increases, old rules can suddenly become useful to creditors. There was a case in Pennsylvania where an adult son became responsible for a large unpaid nursing home bill connected to his mother's care. That case matters not because it happens every day in every state, but because it shows the direction of risk. Nursing homes are businesses. States are under pressure. Families are emotionally vulnerable. When a bill is unpaid, someone will look for a payer. That someone may be the estate. It may be the house. It may be the adult child. It may be all of the above, depending on the facts and the state. This is why elder care planning is not only about the senior, it is about the entire family balance sheet. It is about the surviving spouse. It is about the children. It is about the inheritance. It is about avoiding a forced sale at the worst possible moment. Now let me turn to the healthy spouse, because this is another place where families misunderstand the protection. If one spouse enters a nursing home and the other remains at home, the system does not necessarily require the healthy spouse to become completely impoverished. There are spousal protections. There is an amount of countable assets the at-home spouse may be allowed to keep. The rules are often referred to through the Community Spouse Resource Allowance. On paper, the number can look meaningful, but money looks different when you divide it across time. A sum that appears large today can become small when it must support a person for 10, 15, or 20 years. The healthy spouse still has property taxes. The healthy spouse still has home repairs. The healthy spouse still has food, utilities, insurance, medicine, and emergencies. And the healthy spouse is also dealing with the emotional cost of a husband or wife being in care. This is where numbers can become misleading. A rule that looks protective in a statute can still leave a surviving spouse financially fragile in real life. I think about this the same way I think about any system under stress. When a system is healthy, small shocks can be absorbed. When a system is fragile, small shocks become cascading failures. A nursing home bill is not a small shock. A long Medicaid penalty period is not a small shock. Estate recovery is not a small shock. A lawsuit from a nursing facility is not a small shock. If the family has not planned in advance, these shocks do not arrive one at a time. They stack. That is how wealth disappears. Not usually in one dramatic event. It disappears through a sequence of rules that families did not know existed. A gift here, a transfer there, a nursing home admission, a Medicaid application, a penalty period, an unpaid bill, a lien, a death, an estate claim, a forced sale. Each step seems connected to the step before it, but the whole chain was avoidable if the family understood the system early enough. Let me give you a simple example. A widow transfers money to her daughter over several years. The transfers are not extravagant. They are normal family help. Some birthday checks, some holiday checks, maybe some help with a car repair. The mother does not think she is doing estate planning. She thinks she is helping. Then she enters a nursing home inside the look. Back period, the state reviews the transfers. The transfers are totaled. The penalty is calculated. Medicaid does not pay for the penalty months. The nursing home bills the family. The mother cannot pay because the money is gone. The facility pursues the house. Then, after the mother dies, the state seeks recovery for additional care costs. The daughter who received the gifts receives a letter that effectively says the family home may need to be sold. Nothing about that sequence requires evil intent. That is what makes it so dangerous. Bad outcomes in financial systems do not always come from bad character. They often come from not knowing the rules. And when the rules are complex, the people with the least preparation pay the highest price. There are emergency strategies in some cases. One common concept is sometimes called a half-a-loaf strategy. The idea is that when there is no full 5-year runway left, a family may try to preserve part of the assets while using the rest to pay through the penalty period created by the transfer. It can sometimes reduce the damage, but it is not simple. It requires precision. It requires state-specific analysis. It requires an attorney who knows Medicaid planning, not just a lawyer who drafts simple wills. And timing is everything. Once the Medicaid application is filed, options can narrow quickly. This is why emergency planning is never as good as early planning. When people wait until a hospital discharge planner says, "We need to place your mother in a facility," they are no longer operating from strength. They are operating under pressure. Pressure is where families make bad decisions. Pressure is where they sign forms they do not understand. Pressure is where they spend assets in the wrong order. Pressure is where they forget to ask the one question that could have changed everything. That question is simple. What planning should have been? The document that often belongs at the center of that conversation is called a Medicaid Asset Protection Trust. You should know that name. You should say it out loud if you speak with an elder law attorney. A Medicaid Asset Protection Trust is typically an irrevocable trust. Assets are transferred into the trust. The trust, not the individual, owns them. The person may still be able to live in the home if the home is placed in the trust. The person may be able to receive income under certain structures. But the person generally cannot take the assets back the same way they could with a revocable living trust. That is why the structure can work for Medicaid planning. It changes ownership in a way that after the look-back period passes may place the assets outside the Medicaid countable resource system, but the word after is critical. After 5 years, not immediately, not once the paperwork is signed, not once the attorney is paid, after the trust is properly funded and the 60-month period has run. This is where many people make a second mistake. They create documents, but do not fund them. An unfunded trust is like a bridge drawn on paper. It may look useful, but it does not carry anyone across the river. If the house is not deeded into the trust, if the assets are not moved, if the ownership has not actually changed, the plan may not do what the family thinks it does. Planning is not the binder. Planning is the completed transfer, the right records, the right timing, and the right legal structure for that state. In some states, there is also a tool sometimes called a Lady Bird deed or enhanced life estate deed. It is not available everywhere. Where it is available, it can sometimes help protect the home from probate and certain recovery issues while allowing the owner to keep control during life. But again, this is state-specific. The tool that works in one state can be unavailable or ineffective in another. That is why generic estate planning is dangerous in this area. A simple will is not enough. A will controls what happens to property after death if the property remains in the estate. It does not stop a Medicaid look-back penalty. It does not automatically protect assets from estate recovery. It does not make nursing home bills disappear. It does not begin a 5-year clock. A will may be part of an estate plan, but it is not a long-term care asset protection plan. This is why I want people to understand the incentives. A senior walks into an attorney's office and says, "I need a will." The attorney drafts a will. The senior leaves feeling responsible. But if no one discussed Medicaid, nursing home risk, look-back rules, estate recovery, deed structure, spousal protections, trust funding, and state deadlines, the most important problem may not have been addressed. The family may have purchased the wrong tool for the real risk. That is not always because the attorney is bad. Sometimes the client asked the wrong question. Sometimes the attorney is not specialized. Sometimes the topic is uncomfortable. Sometimes the family is trying to save money, but saving money on planning can become extremely expensive later. There is a large difference between a general estate attorney and a certified elder law attorney. A certified elder law attorney, often called a CELA, is supposed to focus on the kind of issues that arise when aging, healthcare, public benefits, long-term care, asset protection, and family wealth all intersect. That is the type of expertise a family needs when Medicaid planning is the issue. Not every family needs the same structure. Not every family should put every asset into a trust. Not every state treats everything the same way, but every family with a home, savings, and aging parents should at least understand the risk. The dangerous strategy is not choosing a different plan. The dangerous strategy is having no plan because nobody explained the danger. Now, what should a family actually do? I would begin by getting clear about the last 60 months, not emotionally clear, factually clear. Pull the bank statements, look for transfers, look for gifts, look for checks to family, look for assets sold for less than fair market value. Look for large charitable contributions if your state treats them as relevant. Look for forgiven loans. Look for titles changed. Look for any movement of money or property that a caseworker could later ask about. This is not about judgment. It is about exposure. You cannot manage a risk you refuse to measure. Then I would identify the correct professional, not a general lawyer who happens to do wills, not a friend who once handled a probate, not someone who says, "We can probably figure it out." I would look for a certified elder law specialist or an attorney whose practice is centered on Medicaid planning in the state where the person lives. State law matters. County administration matters. Timing matters. Documentation matters. Then I would ask direct questions. Do we need a Medicaid asset protection trust? If so, what assets should go into it? What assets should not? What rights can be retained? What rights would destroy the protection? When does the look-back clock begin? How exactly is the trust funded? How is the deed recorded? How are bank and investment accounts handled? What happens if care is needed in year 3 instead of year 6? What happens to the healthy spouse? What happens after death? What estate recovery rules apply in this state? Are there Lady Bird deed options here? Are there other home protection options? What documentation should be preserved? What transfers from the last 60 months create exposure? The quality of the questions determines the quality of the planning. Most families do not lose the house because they could not afford a conversation. They lose it because the conversation never happened. And if a trust is appropriate, I would fund it immediately. Not someday, not after the holidays, not after the next doctor visit, immediately. Because the 5-year clock is unforgiving. It does not care that you meant to get around to it. It does not care that your children were busy. It does not care that the attorney appointment was delayed. It measures time mechanically. In this kind of system, intention does not protect assets. Action does. I would also tell the adult children, this is not only the parents' issue. The children may be the ones who receive the letters. They may be the ones dealing with the nursing home. They may be the ones managing the estate. They may be the ones trying to keep the house. And in some states, they may even be exposed to claims for unpaid care. Families often avoid these conversations because they feel uncomfortable. But avoiding discomfort early creates crisis later. I have learned that the best time to discuss difficult realities is before the reality becomes a forced decision. Money conversations are hard. Aging conversations are hard. Long-term care conversations are hard. But losing the family house because no one wanted to discuss them is harder. Now let me zoom out and say what this is really about. It is about how systems transfer wealth when individuals do not understand rules. A family spends 40 years building a small amount of security, a house, a savings account, a little investment portfolio, maybe a car, maybe some life insurance. Nothing extravagant. Then one health event changes the equation. The family enters a system designed around eligibility, reimbursement, recovery, and documentation. The family enters emotionally. The system operates mechanically. When emotion meets mechanics, mechanics usually wins. That is why principles matter. One principle is that you must distinguish between ownership and control. Another is that timing is an asset. Another is that liquidity matters. Another is that rules differ across systems. Another is that simple documents do not solve complex risks. Another is that legal structures only work when they are properly executed. Another is that you cannot wait until the crisis and expect crisis options to be as good as early options. These are not abstract ideas. They are the difference between leaving a house to children and watching it sold to repay care costs. They are the difference between a healthy spouse having stability and a healthy spouse being reduced to whatever the rules permit. They are the difference between adult children receiving an inheritance and adult children receiving a bill. I do not say this to frighten people for the sake of frightening them. Fear by itself is not useful. Clear fear can be useful if it leads to action. The right response is not panic. The right response is to map the risk, find the right professional, ask the right questions, create the right structure, fund it correctly, start the clock, document everything, tell the family, then review the plan as laws and circumstances change. That is how you deal with systems. You do not yell at the system. You do not assume. You study it, understand its incentives, and position yourself before it acts on you. The 5-year rule is not really a 5-year rule. It is a test of whether a family understands time. If you understand time, 5 years is a planning window. If you do not understand time, 5 years becomes a punishment. That is the difference. And the difference may be the house. It may be the savings. It may be the dignity of the healthy spouse. It may be the inheritance for the children. It may be whether a lifetime of work ends as a legacy or as a liquidation. So if you take one thing from this, take the phrase Medicaid Asset Protection Trust. Know it, ask about it. Ask whether it applies to your situation. Ask whether your state has related deed strategies for the home. Ask before care is needed. Ask while time is still on your side. Because once the nursing home bill is already due, once the Medicaid application is already filed, once the penalty is already calculated, once the estate recovery letter has already arrived, you are no longer choosing from the full menu of options. You are choosing from what remains, and what remains is almost always less. The system rewards those who prepare early. It punishes those who discover the rules late. That is not how I wish the world worked. It is how this system works. And in investing, in debt cycles, in policy, in family wealth, and in aging, the people who survive are usually not the people who complain most eloquently. They are the people who face reality first. The 5-year clock is either running for you or against you. If nothing has been done, it is not running in your favor. That is the point. The day the right assets move into the right structure, the clock begins. The day after you should have started is the day that may cost your family the most. So do not wait for a hospital discharge. Do not wait for a diagnosis. Do not wait for a nursing home administrator to explain your options. Do not wait for the state to tell you what you should have done. The people who are supposed to explain this often arrive after the decisive moment has already passed. You must act before the moment. That is how families protect wealth. That is how they protect the house. That is how they turn a system that can punish ignorance into a system they can navigate with clarity. And clarity in a world of complex rules is often the greatest protection you have.